Hey y'all, Daniel Gaines here. I'm now home again for the evening, actually. Get to take a slight break. Got to work on things, but I'm not actually going to be working tonight. Uh, However, I'm here to show these court filings that I've done. To give y'all a better idea and more of an idea of exactly what it is that's going on and what I've done and everything else. So without a lot of yapping and bullshitting, we're going to get into some stuff. Hope y'all ready? As you can see, questions of law, and there's 10 of them. Applicable laws. I'm not going through everything word for word. It can be paused and looked at and such like that, but you look up any one of these laws, look up any of the case law, case precedent, any of it, and you will see it is all valid and standing. And again, there's a lot of it. We're already on page 7 of the shit, and this is just in one filing. Not lying, page 7. Still going. See, so when I say I actually do this shit, I really mean I do this shit. These fuckers claim that I don't know what I'm talking about, blah blah blah, but yet it's all here. Y'all can, like I said, everyone who watches this, even the court actors and state actors and government actors who watch my page, DCYF. Matter of fact, real quick, why doesn't everybody who works for DCYF, the courts, the state, the governments, any government actors, any attorneys, anything like that, I'm going to go ahead and need y'all to sound off in the comments. Go ahead and state your name, occupation, and such like that in the comments. As y'all know, the law requires you to divulge that information when it's asked or requested. And at this time, it is being asked and requested. Any of you fucks that are watching my shit, sound off in the comments. I want names. I actually already have the names and information. I just want to see if they're going to comply with the law, because otherwise I'll be pulling the information that I've had for several months and using that to further my federal action against them for failing to comply with their legal obligations. But anyway, let's keep going. Page 11. And we're still in the case law section. Alright, now let's get into it. In the matter at hand, we have many serious issues that must be addressed by the courts, ranking from lack of proper service on the record and on its face, all the way to the severe deprivation of rights under color of law that exists and are clear on the record. The courts must also answer the question of is due process guaranteed under the 14th Amendment requirement in all legal matters. And then it goes on to address how Juliet lied, blah blah blah. I'll get into this a little bit into detail. Just be warned that this video is probably going to be broken up into several parts because there's multiple filings, and one of my filings is alone is 120 pages. I'm not going to be going over all the evidence and such, so it's not going to be the full 120 pages that I'll be showing, but there's still quite a bit. It says, when Juliet in 2004, when she filed these documents, she used the false address of her friend Melissa Roth, who was a Washington resident. In her filing, Ms. Parker admits that she lived in the state of Louisiana when she admitted that all her and her child's belongings were in the state of Louisiana. This also shows and proves beyond any doubt that Ms. Parker, upon leaving the state, had every intention to return to the marital home. Upon her arrival at the marital home, located at 178 Marsh Street in Louisiana, Thibodaux, Louisiana, Melissa Roth was with Miss Parker. This is a fact that cannot be ignored. However, there were 0 documents served upon Mr. Gaines that night. Further, Louisiana law requires that for service to be proper, service must be done by a sheriff, law enforcement officer, or one who is registered with the courts and who lives in the parish they wish to serve in. Updated in 2011, see Louisiana Revised Statute 13.3204, Service of Process. Now, keep this in mind because Juliet submitted a filing recently where now she's claiming that service was proper in accordance with Louisiana law. Before this was stated, the actual site for the code, it was always service was proper with Washington law. Anyway, Miss Roth, as a Washington resident, does not qualify as someone who can serve legal documents in the state of Louisiana. As such, error exists on its face and on the record in this matter. That legally leaves the courts and its referees little choice in this matter, yet for some reason the courts refuse to address the errors or even offer a venue for remedy. Remedy, which is mandatory under the laws of the state as well as the laws of the United States of America. Further, the courts had and still have a complete lack of jurisdiction. This court, as well as others, refuse to address the jurisdictional issues. Their refusal to address the jurisdictional issues is astounding and illegal, as jurisdiction is vital in all legal matters, both civil and criminal. Jurisdiction over the parties is called in personam jurisdiction. It originates from one of any of the following sources. Now, here's where it gets interesting. It must originate from one of the following sources. Live in the territorial jurisdiction of the courts. I'm a Missouri resident. The courts are in the state of Washington. Operate a business in the territorial jurisdiction. Again, never lived in the state. Own property inside the jurisdiction. Never lived there. Commit an injury in the territorial jurisdiction. I'm the injured party. So obviously, I've committed no injury. They've committed injury against me. In addition to the 4 elements above, the parties to the suit must also have had notice and opportunity to respond. In most cases, they must be personally served with the pleading, for instance, by process server in order to make them parties to a suit. Proof of jurisdiction must appear on the record. Once the court has knowledge that subject matter jurisdiction is lacking, the court, meaning the judge or decision maker, has no discretion but to dismiss the action. Failure to dismiss the action means that the court is proceeding in clear absence of all jurisdiction which subjects the judge to suit. These fucks think I don't know what I'm talking about, but yet here it is. Personal jurisdiction is not usually an issue in most proceedings, but subject matter jurisdiction always is an issue. Subject matter jurisdiction is not everything, it is the only thing. Subject matter jurisdiction requires a competent witness or notarized affidavit demonstrating an injury, a statutory or common law basis for a remedy to the injury, and neither one of those are applicable. Whereas personal jurisdiction can be waived, it is not in this matter, and the record shows a complete lack of any signed document showing jurisdiction was waived. On the record and on its face, the state lacks subject matter jurisdiction as a child in question was born in and a resident of the state of Louisiana. The birth certificate of the child shows subject matter jurisdiction over any and all matters related to the child would be in the state of Louisiana, especially given the fact that prior to these illegal orders, the minor child had only ever lived in Louisiana. And it goes on. Again, it can be slowed down, paused, and all that shit to be viewed, but it's all there. Black and white. I'm only going through it quick, trying to hurry up and get through shit, because I really want to get to the filing I did today. That way y'all can see that one, because that one is the one that's really me being an ass. But I mean, all the exhibits and blah blah blah. See, I actually do this shit. Regardless of what they want to claim, I actually do this. This one's only 4 pages. So let me put my cigarette out real quick. Again, kids, don't smoke. It's stupid. And I'm an idiot for doing it. I don't argue and won't argue that fact. However, I gotta have something for stress. That's why I smoke weed. Without something for the stress, yeah, it would not go well. These motherfuckers, they don't care. They don't care what kind of damage it does to a person or not. They think they're unfucking touchable. Well, I'm about to reach out and touch them and show them they ain't shit. And I don't mean physically, I mean through the courts. So before anybody wants to start fucking twisting shit, get it fucking right, you jack-offs. Fucking punk-ass bitches. That's not to the good folk that watch this. That's them cock-sucking fucks from the courts and the state. Anyway, Ms. Parker continues to make false claims to the court in an attempt to further cause a deprivation of rights against me. This is evident by the fact that in Ms. Parker's declaration, she falsely claims that Judge Johnson allowed the change of venue to Mason County. However, what Ms. Parker failed, and with intent to miss in her declaration, is that her then attorney who filed the change of venue only asked the courts to transfer the custody parenting plan to Mason County, which the exhibit is attached, to which Judge Johnson did sign the order. The order sent the child custody matter alone to Mason County and nothing else. The facts still show that this court is the only court to hear this matter. In this, we are dealing with a matter that has many challenges. One such challenge is quorum non judice. This court lacked the authority to hear this case as well as lacked the authority to issue any orders in this case, especially any orders that resulted in a judgment awarding any monetary reward of any type. This default order is no exception, and I am asking the courts to declare the default judgment void. A party affected by void judicial action need not appeal, blah blah blah, case law. If an appeal is taken, however, the appellate courts may declare any void orders the trial court signed after lost plenary power over the case because a void judgment is a nullity from the beginning and it is attended by none of the consequences of a valid judgment. This cannot be ignored. It's fact recorded. Judgment is void if the court that rendered it lacked jurisdiction of the subject matter of the parties or acting in a manner inconsistent with due process. And then we just get into the federal rules of civil procedure. And then we get into this now here. I will offer a breakdown of all points I have listed and how they apply, complete with evidence. 3. Fraud, misrepresentation, or misconduct by an adverse party. It cannot be argued that there is clear misconduct for one party in a matter to go to a different state and file divorce, custody, and child support matters. As a resident in the state of Louisiana, Ms. Parker did engage in misconduct by filing these matters in the state of Washington. Further, it is misconduct on her behalf of the courts in the on behalf of the courts in the state of Washington to hear this matter when the addresses of all parties involved is listed in the documents as being in the state of Louisiana. Exhibit B. It is further evident by the fact our daughter was born in the state of Louisiana. Exhibit C. In total, these documents that are the original filings in this matter confirm that this matter should have been heard by the courts in Louisiana, not the courts in the state of Washington. 4. Circumstances under which a judgment is void. This is proven based on the above exhibits in the Washington State Appellate Courts, which ruled a void judgment, decree, or order entered by a court which lacks jurisdiction of the parties or of the subject matter, or which lacks the inherent power to enter or make a particular order involved. It just goes into more case law. And then number 6, any other reason justifying relief from the operation of the judgment. This is evident by the fact that my 14th Amendment right to due process was and still is being violated. The service in this matter was not proper according to Louisiana laws related to service of documents. In the state of Louisiana, to serve documents, one must be registered. One must be a resident of the parish one wishes to serve documents in, as well as one must be registered with the courts. Mrs. Roth is not either of those things as a resident in the state of Washington. Exhibit D. Further, even in this fraudulent proof of service, the courts can see the address of the alleged service took place in the state of Louisiana. As such, this was not proper under the law, which translates to a violation of my due process rights. 14th Amendment to the United States Constitution gives everyone a right to due process of law, which includes judgments that comply with the rules and case law. Most due process exceptions deal with issues of notification. If, for example, someone gets a judgment against you in another state without your having been notified, you can attack the judgment for lack of due process of law. And then we get into more case law. And then this last part here is Colorado, but it still says relief is discretionary matter, or it is not discretionary matter, but mandatory. Now, the reason I showed that is because it's going to become relevant here in just a moment. I'm getting there, don't worry. Here's a 7-page document. This one isn't really much, so I'm just going to skip it for the most part. As y'all can see, it's just more going over her and her criminal conduct, false documents, and blah, blah, blah. Yep, so just a bunch of blah, 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 more shit. Let's see. Not that one. Sorry, that one said draft. Didn't realize it. This one's kind of comical because, here, I'll read the first part of it. I won't read all this one again because I want to get to the last one. I want to try to keep it to one video, just for time purposes. But anyway, Ms. Parker started her declaration signed under penalty of perjury with a claim that has never been made before this current filing. She claims she fled the state of Louisiana to get away from me due to my being very abusive. This claim has not been made in any document, blah, blah, blah. But again, more bullshit, more lies. Y'all can look through it. Y'all can go over it. Check out what I cite, what I use, and everything else. Because again, all valid, all standing. Anybody can fact check me on this. Anybody can look into this shit. I don't make shit up. I don't lie. Don't have a reason to. It's all here in black and white. All filed with the courts. So, let's get to the good one. I'm going to go ahead and skip this other one because I want to show hers and then my response today. She said the respondent has filed some kind of motion for which I am not completely sure he is aware of the statute of legal procedure. Files a motion which I believe he is attempting to set aside all the orders in the dissolution which was granted by this court after he was properly served in the state of Louisiana by one of my friends who had the assistance of local law enforcement departments of the local law enforcement department. And again, that claim's never been made, ever. It's never been proper under Louisiana law. It's always been proper under Washington until I cited the Louisiana law. Now it's changed again. Anyway, Mr. Gaines decided that he would not participate in the delusion and in fact defaulted. Blah, blah, blah. Judge Johnson sent it to Mason County, which again, only the custody. The courts in the state of Washington have stated child support and child custody are two separate matters, so they tied their own hands. She's asking for money, for attorney fees, blah, blah, blah. So now let's get to the good shit. This is where I kind of become an ass. This is where you can tell I'm kind of pissed. And this one is 4 pages. In the latest filing of Ms. Parker, she once again makes a number of knowingly false claims. To make matter worse, her attorney, Stephen Downing, knows these things to be lies, yet still files documents he knows to be perjured and false. According to the case law already filed by me, I'll cite on the record during the hearing as I'm not typing it again, Mr. Downing is guilty of a state and federal felony fraud upon the courts. The court's, refusal to address this issue when it's been not only brought up, but proven many times is shocking. The judiciary has a lawful obligation it must comply to. The repeated failure to do so begs many more questions than it could ever answer. Knowing beforehand this court, specifically the commissioner, will not address any of these issues, it is pointless to type it all into a document when it's easier to state on the record and add to my federal action. Back to the point. Ms. Parker, with intent, claims to not know what this is about, yet my filings speak of the child support and lack of service and jurisdiction with very little else. Any reasonable person will be able to read my filings and know what the issues are. She makes these claims in the hopes that the commissioner will jump on the chance to find an excuse to toss this matter out of the court and rule again in violation of the law. Oh yes, this was straight stated to the courts. Ms. Parker claims now that Good thing this is just a draft and hasn't been filed yet. Now that Ms. Parker now claims the service was proper in accordance with Louisiana law, this is contrary to her last filing in the matter where she states service was proper in accordance with Washington law. Since the two state laws differ, it would not be possible for service to comply with both. Further, this is the first time ever Ms. Parker has claimed service complied with Louisiana's law, as well as the first time Ms. Parker's claimed that officers were present. I find it odd how Ms. Parker's claims change. Sorry, I'm noticing some errors. Each and every time I file a response to her claims. If the courts would take notice, and yes, that is exactly what it says. Where am I at here? See, they will see Miss Parker is unable to provide any evidence to her claims, nor is she able to cite a single piece of case law to support her claims and filings. It is shocking that any court would allow such action to take place, even worse when it's common practice for the courts to flat out ignore the 14th Amendment altogether. Yet time and time again I prove this is exactly what takes place and nothing changes, which is why this time the intent is to go to the appellate courts. Ms. Parker also falsely claims that I chose not to show up to the hearings, which resulted in a default. Yet according to the law, a default must still be proven to be valid Yet once again, not one single piece of evidence exists on the record. However, since the courts are well aware of the fact that service was not proper, when one party does not receive any documents, how can they be present in court? Further, I have challenged jurisdiction literally at each and every hearing since I've known about this. Not once has any court in the state of Washington addressed this issue. I have proven the lack of jurisdiction time and time again. Not a single person has argued this point to date, yet ignored by the courts when once again there is a legal obligation to address this issue. And with Ms. Parker having the burden of proof of both proper service and proper jurisdiction, I am still waiting for any type of proof to be filed into this case to show either. Ms. Parker further states Judge Johnson transferred jurisdiction to Mason County in 2015. Date error aside, as it was 2014, that change of venue specifically states child custody, not a single mention of child support. With Commissioner Farmer already stating that child custody and child support are two separate matters, that change of venue would have needed to state both in order for both to be sent to Mason County. Getting into this more, since I've already filed all the proof of this into the matter, the change of venue from 2014 is void, as there was again on the record a lack of service. I am to be notified of any action in any case that lists me as a party. This is how due process works. Yet on the record there is no service of process, and no mention of Ms. Parker even trying to notify me. However, since this is about child support and not child custody, I find this claim to be moot, and as should this and any other court. Ms. Parker claims she has no idea why I would file this when our daughter is 18. Yet as stated, this is about the violation of my protected rights and the law. Further, Ms. Parker also knows that I have tried to have this addressed over the years and in other states as well. This claim is again false, and Ms. Parker is well aware of it. However, again, I notice not a single piece of evidence to support her claims. I was under the impression due process requires that the one making the claims has to prove their claims. Yet Ms. Parker, being a female, has never been held to this standard. Instead, I am forced to prove her claims that are false, only for the judiciary to ignore her crimes, which is again shocking since the judicial canons of the state of Washington, Canon 1, Rule 1.1, states a judge must comply with the law. This is also ignored and will be once again by this member of the judiciary. Further, Ms. Parker asked for this matter to be dismissed, yet has failed to show any reason for it to be dismissed. She has cited zero law and zero case law to support her request. She also has failed to file any evidence to support her claims. Then she is asking for attorney fees. This is an excessive fee that cannot be given to her. I am the party that has cited the laws. I am the party that has filed the case law. I am the party that has filed the proof of each and every claim I make. I am the only one who can state this and it be factual. As such, no fee should be assessed, as none will be paid, even if ordered. The explicit purpose of all this is to get to the appeals court, nothing more. With that being said, I do wish to make the courts aware of the extent of things. Mr. Downing has once again failed to comply with the rules of discovery of documents. The documents filed by Ms. Parker into this case since the renote have yet to be given to me. As such, I am requesting the courts throw them out. Due process must be complied with in all matters. This is far from the only time Mr. Downing has done this. In fact, Mr. Downing has failed to give me any documents in a timely manner. He files documents late, knowing he has to give me sufficient time to read and reply, and in that regard, I cannot be held to the same standard as the attorneys, which all of you are aware of. Yet y'all refuse to address this when it's brought up at each and every hearing, which is going to be more for the appellate courts to address since you criminals won't. Finally, I find it odd how I have cited more than 200 pieces of valid and standing case law and have cited more than 50 legal codes since the start of all this. Judge Johnson, Judge Murphy, Commissioner Farmer, and one other have all been forced to admit my laws and case law are valid and standing. Yet the other side of this changes their story each time I respond, cites zero case law and zero laws, as well as files zero evidence into the case, yet for some reason each time I am the one being ruled against. It's almost as if the courts, judges, and commissioners, attorneys, Miss Parker, and others are working together to deprive me of my rights. Also, the state can collect child support and gift it to Miss Parker, so the state can then in turn receive federal funds through the Title 4D program. Now, if this is the case, I am sure the member of the judiciary, as well as the others involved, should know that this is a violation of the RICO Act, which is again shocking. However, that will be proven during the federal suit that is going to follow the appeal that will follow this. So until then, y'all can decide if you wish to fully and properly address this or if this goes federal. The motion for summary judgment will be filed Monday after the courts close, so it can be denied during the hearing when you violate the law and again act without jurisdiction. I guess y'all think I'm too stupid to know that one of the two ways to get around judicial immunity is by a complete lack of jurisdiction. How you can believe this when I have already filed the info is astounding. However, knowing that even with all the proof I have filed and the complete lack of proof filed by Ms. Parker, as well as the discovery issues by Mr. Downing, I am well aware that this member of the judiciary does not have the brains to comply with the law and will once again ignore my rights. I am prepared for this to happen and expect it. This is also why this is only being done to get to the appellate courts. This part I love. You state courts can kiss my hind parts, as I owe you zero respect whatsoever due to your criminal deprivation of rights. And, in a nutshell, that's my filings. They're extensive, as you can see. There's a lot. And just in the one document, document alone that I showed, there was 9 pages of case law. There was a page and a half of legal codes, and that's just one filing. Now, all the documents I've shown, all the court hearings I've shown, y'all have heard me cite shit, y'all have seen the shit I've cited. Y'all can look through anything and you'll find that there's very little overlap in my case law. I don't repeatedly cite the same shit. I don't go into this sounding like a broken record with anything other than the claims I make. The accusations I make, I sound like a broken record because they are all the same. However, the case law that I cite and the legal codes I cite, very little of that does overlap. Now, there is a little bit. I can't sit here and pretend that there's none, but there's very little. And again, like I said, it's going to be ignored by the courts and all that bullshit and blah, blah, blah. But that's fine because that's expected. These fucks really think that I expect that I'm thinking that they're going to actually comply with the law and all these steps and all this during this process. That's where they're sadly mistaken. I already know they're not going to comply with the law. I already know how they're going to rule. I put it in videos. I put it in court filings that they're going to rule against me, ignore the law, and everything else. That's what state courts do. You have to be prepared to send this to the appellate courts. Now, because Washington State has a 10-day deadline, is what I'm going to do is I'm going to file the revision. I've actually got it all done and ready to go. I just need the order to be signed by this clown in the robe on Tuesday. That way I can put the reasons in my revision, and then I'll file that. That'll kick a court date out at 7 to 14 days, anywhere in that range. And then I'll have 10 days from the date of that order to get my appeal filed. So essentially, I'm giving myself 2 weeks to a month, give or take, to get to appeal this. So the only reason I'm even doing this, like I said, the explicit purpose for this is to get to the appellate courts, and I'm going to give myself the time I need to make sure the appeal is solid. However, I'm setting them up at the appellate level too because I'm not appealing everything. I'm only appealing this child support ruling. And when the appellate court finds that the courts did in fact act without jurisdiction, there was in fact improper service, it was in fact deprivation of rights, criminal deprivation of rights, and everything else, that's all going to be included in my federal action, because then none of these corrupt judges or attorneys or anybody else can claim that, well, there's no deprivation of rights. No, because the state appellate courts already found that y'all are guilty of this shit. Y'all just refused to fully address this shit whenever I brought it to your attention. Therefore, now you're fucked at the federal courts, because I've already got the documentation that says y'all are fucked because y'all are criminals anyway. They really don't... They're missing the forest for the trees. It's a common expression I use because people get too narrow-minded and too narrow-focused on things. They don't look at the big picture. They don't plan ahead. If more people would actually look at the big picture and plan ahead, things would be a lot better off. But when you're dealing with extremely biased liberal fucking courts who think that straight white men like myself are in public enemy number one, this is going to happen. They're going to love the shirt I'm wearing for Court Tuesday because it says hetero alpha male on it. And I'm going to make sure that the courts get a very good fucking thorough view of what the shirt says, just to let them know who the fuck they're dealing with. I am that straight white alpha male y'all fucking can't stand and y'all think are the public enemy number one. I'm going to show y'all why you shouldn't treat us as public enemy number one, because then you fucking target yourselves. But otherwise, y'all have a good one. I love y'all. I'll see you on Tuesday whenever I post the court hearing, because I can promise you Tuesday's court hearing will be the next video I post, because even if they tell me not to, I'm going to laugh at them and do it anyway. And I'm also going to let it be known I'm showing the shirt for not only the courts, but for all my YouTube people who watch the video, so they can see exactly who the fuck the courts are dealing with. So yeah, I'm an ass and I know it, but I'm only an ass when I'm pushed to be one. Don't make me an ass and I won't be one. Don't make me a fucking danger to you and I won't be one. And when I say danger, I mean through the legal system. Because these fucks will try and twist my words to engage in a malicious prosecution to try and come after me, because I'm challenging them. And I have the balls to stand up to them. This is what I got for them. Fuck you. The rest of you, I love you. Have a good day. All you state actors, DCYF, fucking attorneys, government actors, state or government contractors, or anybody else who's watching this page, don't forget, I need y'all to sound off in them comments. Let me know you're here. You've been requested to identify yourself. Now you must comply with the law and do so. Peace out. I love y'all. Have a good one.